now, the Supreme Court ruling moments ago, the recess appointments made by President Obama to the National Labor Relations Board without Senate confirmation were illegal. Here now with more, Jay Sekulow, Chief Counsel of the American Center for Law and Justice. And fortuitous to have you here because you are a part of this now. What does the ruling mean, Jay?
Well, what it says is that in this particular case, the appointments by the president, the so-called recess appointments to the National Labor Relations Board, were not valid because the House and Senate, they were in recess, and therefore the Senate was in recess, and that the House basically has the calendar control. And that was a key thing that we argued, by the way, representing the Speaker of the House, John Boehner, in the case. So we represented the Speaker. So the appointments, Bill, that were made during this period by those three NLRB so-called recess appointments, the decisions made by the National Labor Relations Board during that time frame were not valid. So they're of no effect, at least during that particular time.
This is a slap down about executive power, then.
It's a significant victory for what's called the separation of powers, and yes, the president just doesn't get to make up the rules on when the Senate is in recess. So he just can't appoint people because he's mad at the United States Senate or Congress. So they said they were in pro forma session, which is what we argued, and 9 justices agreed with that.
9-0. Wow. So you can do recess appointments, but in this case, Congress was not in recess. That's what the court's saying, correct?
You got it. That's exactly right. They said a 3-day to 10-day window of time in recess is too short to say they were not in recess. Okay. They were in recess.
So the appointees that went through during that time, what happens? Are their names withdrawn? Do you go back to the drawing board? What do you do, Jay?
It's as if, Bill, they were never on because they were not properly appointed. Therefore, they are not officials of the NLRB, and the decisions made during that time frame were, when they were serving on the NLRB, the National Labor Relations Board, are null and void because they weren't in effect. So what you got is basically a reversal of those decisions because they had no authority to make those decisions in the first place.
I'm still waiting on Hobby Lobby, which, as you know, is a big one, too, and maybe it could still come today. It's possible, but in all likelihood,
Justice Scalia is still
Monday.
reading from his concurring opinion in the last few minutes on this case, on the NLRB
Monday's
case. So
Monday's the drop dead date, right? Because that's the end of the session, June 30th.
Yeah, and they could even decide to have a scheduled order day tomorrow. That's not unusual for them to add a day and just make an orders list Monday. We'll know that at the end of probably around 30 minutes from now.
Thank you, Jay. Jay Sekulow. Appreciate it. Thanks.
All righty, Bill.
All right.